Good morning, everyone. On behalf of Employers Group, we'd like to welcome you to this morning's webinar on immigration. Before we get started, I want to share a few words about our presenter this morning. Angelo Paparelli is a partner at the law firm Sathar Shah and is the founder and immediate past president of the Alliance of Business Immigration Lawyers, a 40-member worldwide alliance of leading immigration firms. Angelo has substantial experience in advising and defending employers in U.S. immigration compliance and enforcement actions. Angelo has been rated 3 times as the world's leading corporate immigration lawyer in their annual peer rankings of the International Who's Who of Corporate Lawyers, and as a star individual in immigration law, the highest rating by Chambers and Partners in both 2011 and 2012. He is a 2010 recipient of the Edith Lowenstein Award for advancing the practice of immigration law. He also blogs on solutions to America's dysfunctional immigration system at www.nationofimmigrators.com and co-authors the immigration column for the New York Law Journal. Now, without any further ado, here's Mr. Paparelli.
Well, thank you, members of the audience. I very much want to make this a useful session, and I also want to note that there will be more than commonly be covered in the allotted time, and as a result, you have access to the entire PowerPoint presentation, including near the end several pages of resource materials, so that if something is not covered, you should be able to find further discussion, and I welcome any communication if you have a question. We will have a question and answer session near the end, so let's begin. We have had numerous trends in the enforcement of the immigration laws, the employer-based immigration laws, in the recent past. One significant factor to note is that in Crystal City, Virginia, the U.S. Immigration and Customs Enforcement, or ICE, has opened an employer compliance center and stationed it initially with, I believe, 15 officers who spend full time handling large volume audits from the field offices. So it used to be that there was some restriction on the ability of the field offices to handle large employers in their auditing, and that's no longer the case. So beware of that. Beware also that notices of inspection are being snowflaked across the country. The agency follows up with audits, and there are a number of practice pointers that you need to be aware of. Do not self-defend an audit. It's not advisable. It's better to get counsel. The ICE folks are very willing to fine for the most minor of errors, and they seem to be less willing to negotiate or settle the fine proceedings than they have been in trend from the Office of the Chief Administrative Hearing Officer is that they have been more willing to reduce fines that have been suggested by ICE. If we look at some of the recent trends, ICE has been very busy in 2012 with 500 arrests. 240 were owners, managers, supervisors, or HR personnel. They have served 3,000 notices this past year, and 495 has resulted in fines worth more than $12 million. The ICE has the authority to debar businesses who are government contractors and to also impose administrative and criminal violations. The fines can ratchet up very, very quickly, and I'll not go over each and every fine amount, just to let you know, though, that there are 5 different types of fines that can be imposed for paperwork violations of the Employment Eligibility Verification Form. I might mention we're going to cover the new form, and we'll do that a little bit later in the talk. If an individual or employer or recruiter for a fee knowingly hires or continues to employ an individual with knowledge that is actual or constructive knowledge that the worker lacks the right to work, that's a pretty significant fine. Potential so-called document abuse, which I'll describe, other forms of unfair employment discrimination under the immigration laws, and document fraud. The fines can also lead to imprisonment and on a misdemeanor charge, but it's even more powerful that they can lead to felony penalties with much more serious criminal consequences. As well as ICE, we have seen action from a special civil rights division of the Department of Justice known as the Office of Special Counsel for Unfair Immigration-Related Employment Practices. They have been aggressive in their pursuit of discrimination, document abuse, retaliation charges. The agency is one that has very smart lawyers employed and very demanding requests for documents, and so it is very important to engage counsel early if the folks at the OSC come a-knocking. They have intended to agree to settlements, and while these are called no contest settlements, they do impose civil money penalties, and that can be a problem for a government contractor who might lose renewal of eligibility for government contracts or might have a contract interrupted while it's in process if civil money penalties are found. The point to be made here is that, at least in one case I was involved in, the agency removed the phrase civil money penalties, thereby removing the implication there was wrongdoing. The Office of Special Counsel has been established in order to balance the kind of overly zealous I-9 employment verification that might otherwise occur. And so the statute that was passed in 1986 and continues to this day still tries to work a balance between zealous enforcement of employment verification and prudent measures to avoid discrimination. And while there are certain protected classes such as citizens, residents, asylees, refugees, and persons who were granted temporary residence under the old IRCA amnesty or legalization program, that's not the only class of people that can be protected. Document abuse, for example, applies to all individuals who may be asked to provide more than the minimum required, or where the employer insists on a particular document, such as demanding to see a green card. These are the kinds of things that OSC just loves to pounce upon. The protected classes that I mentioned earlier are under the discrimination provisions of the law, retaliation and discrimination on the basis of national origin or citizenship status. You probably know that the EEOC has authority over national origin of employers with 15 or more employees, but the OSC has the nation's only authority to punish violations of citizenship status in hiring, firing, or recruitment. We might mention, however, that there has to be actual evidence of an intent to discriminate. Since 1996, the law has said that statistical evidence is not allowed in, or the so-called disparate impact theory of exposure is not allowed under the IRCA statute, employer sanctioned statute, as it has been amended. Not to be undone, there are other agencies with authority over immigration enforcement. I'll just mention two. We won't get into them, but there are some articles at the end that you can read about. The Department of Labor's Wage and Hour Division has the authority to investigate certain immigration-related labor violations involved in employer sponsorship. And while you may think you are not at fault or in any form of exposure under the so-called labor violations that can arise in this context, I'm thinking, for example, of the H-1B worker in a specialty occupation classification. You may say, well, I don't hire any H-1Bs. If you engage a contractor or vendor that places H-1Bs on your work site, then you could indirectly be penalized for their violations. You'd also have some measure of a duty to cooperate with the vendor to make sure the vendor complies with law. And then most recently we have FDNS, the Fraud Detection and National Security Directorate of U.S. Citizenship and Immigration Services, our friends who bring us the I-9 form. FDNS typically will visit an employer work site and ask questions without prior warning, without calls to counsel representing the employer in advance, ask to see the worker who has been sponsored for a work visa and wants to take pictures. And so there is some risk if there is no cooperation with that request that the worker's visa petition will be revoked. Moving on, we also have another USCIS entity that conducts so-called desk reviews. They look at employers enrolled in E-Verify, the online employment verification database that the government maintains, and for which in some states it is mandatory. In cases involving federal contractors it is mandatory, but it is voluntary and only enrolled pursuant to a signed memorandum of understanding. Well, USCIS has a verifications division that takes a look at your the back end of your use of E-Verify to see if there are any failures to comply. We'll talk about that a little bit, but you should also be aware that that's another entity that can approach an employer for violations. And the other recent trend is that just last Friday, USCIS released a new Form I-9 employment eligibility verification. We'll get into that momentarily. I want to talk just briefly about some comprehensive immigration reform proposals that are affecting employers. It is perhaps the most opportune time in many, many years to anticipate the passage of immigration-related legislation of a comprehensive nature. And as it pertains to employers, the employers can expect that there will be even more enhanced, more burdensome employee verification systems to comply with that will have worker protections for Americans and permanent residents, will do a better job than the current E-Verify to prevent identity theft, and also provide some due process protections for all parties. It is very likely all of the proposals that have been released to date suggest that perhaps over a 5-year enrollment period, E-Verify will eventually be mandatory nationwide. And you may have heard that E-Verify does a very poor job of detecting identity theft. That is true. But there is further discussion among at least the gang of 8 senators who are putting together their proposal, which should be released in April. There is discussion to require even U.S. citizens and permanent residents to have a fraud-proof identification document that will allow them to be verified. And unless everyone has some form of ID that can be verified for employment, it's believed that the identity theft problem of E-Verify will not go away. We also have heard quite frequently that there will be 11 million unauthorized immigrants granted legal status of some sort. Whether it includes a path to citizenship is uncertain, but we should recognize that the grant of some form of legal status will inevitably include some form of work permission. It's been estimated that perhaps 8 million out of the 11 million unauthorized are already employed in the United States and probably using false documents or acting as imposters. Therefore, you're going to see a number of people show up with new names, new forms of legal authorization, and you can envision that it will be like the Social Security no-match situation that you've probably encountered in the past. I'll talk about that a little bit later. Lastly, we should expect that there will be new methods to bring both the best and brightest high-skilled workers, but also future flows of lower-skilled workers. One of the reasons it's perceived that we have inducements to violate the immigration laws is that there is no lawful method that is meaningful and that works to allow individuals to come into the United States to work on a temporary basis. So we have a new I-9, and it is effective today. Actually effective as of last Friday, but there is a grace period that ends on May 6, 2013. Much of the same information is collected on the I-9. I have done an analysis with a co-author over the weekend on my blog, and that there is a link to it in detail. I'm going to go through this very quickly. This is the first page of the I-9. It now only involves the employer. There is also a box for preparer and translator. Excuse me, I misspoke. It only involves the employee on Section 1, and that's in the first page, with the bottom of the first page being the preparer-translator certification. This form is available at the uscis.gov website, and I encourage you to take a look at it. Begin in your organizations to get to know it. This is the top of Section 2, and it deals with the employer or authorized review and verification that occurs on page 2 of the I-9. Now the I-9 is a 2-page form, and as you will see, there is also a space for re-verification procedures. If you look at the bottom, it says page 8 of 9, and we only looked at 2 pages. That means that there are 7 pages of instructions to the I-9 plus a new form manual or handbook that is called the M274, which gives even further detail on how to gear up for the new I-9. And remember, there's only a few months, only until May 6th, before you are required with new hires and re-verifications of existing hires who have had temporary employment authorization to use the new form. What's changed? Well, the instructions are far more detailed. There's specific information that's listed here. I'm not going to go through each of them because I want to allow for time for questions, but as I indicated, there's a blog post that will allow this. There's certain information for persons who receive their authorization at the port of entry for non-immigrant work visa employment, and they must now put in certain information on Section 1. Others would not. They would instead just put NA or not applicable. There are special instructions for minors and the disabled, and there's clarification with regard to the use of receipts for lost, stolen, and damaged documents. Interestingly, they make very clear that certain information is optional. We'll get into that. And the problem with these instructions is that human beings using an inexact method of communication, namely printed words, will interpret things differently, and mistakes, I put that in quote, will occur, and we don't know yet how vigorous and zealous will be the enforcement by ICE. The deadlines to complete the document are clearer, and the document has a new look, which perhaps will awaken in the mind of the employee, new hire, that this is official, and that if they were to misrepresent something on the document, it is a government form, and it does come with the penalty of perjury. The same warning obviously applies to employers. New fields have been added, and these are for employees to provide email addresses and telephone numbers. These fields are optional. That's very clear. It's not clear to me whether I will recommend to employers on a blanket basis to encourage or not encourage or remain mute with respect to the decision as to whether employees will provide their phone numbers and email addresses. This is not like a social media sign-up, so I would say think about it carefully. And the government has also indicated that there's been some improvement with respect of the ability to contact in the event of E-Verify tentative non-confirmations. That only applies if you're an E-Verify enrolled employer. They've changed the names to reflect friendliness. family name rather than last name or surname, and also other names used instead of maiden name, so it allows for a greater degree of flexibility and gender neutrality. As I mentioned, certain persons have to fill out the Section 1 with passport information, but that's only if you receive 994 arrival departure record at the port of entry from U.S. Customs and Border Protection, or CBP. Everyone else would fill out none. No longer they say alien number, they give the choice of alien registration number for persons who have a green card or might be in removal proceedings or might have refugee or asylee status, or USCIS number. This may cause some uncertainty and ambiguity in the minds of some employers, but the numbers are still the same. It's just a different way of referring to it depending on the document in question. We have a mysterious 3D barcode that is not yet used, but we think perhaps USCIS may create a smart I-9 that employers can complete electronically, and that may allow for electronic reading of the form data, which obviously is going to be less burdensome and less prone to error than human frailty. There is a place to record extra List A documents, and the fields have been revised to address the special circumstances involving foreign students with work permission, others with employment authorization, and green card holders. The employer's attestation has changed, and that is something that is to be noted because some employers were uncomfortable attesting to a start date in the future. And now it's more clear that you are not attesting to a future date when you can't possibly predict the future. Section 3 is rephrased modestly, and recording name changes, although it's not mandated, may be a best practice, but only if handled in a way to prevent document abuse claims for purposes of immigration discrimination. The List A acceptable documents have been updated to make the rules regarding so-called restricted Social Security cards clear. Those are the Social Security cards that in various iterations have said not valid for employment, valid for work only with INS authorization, or valid for work only with DHS authorization. Let's go into some suggestions. These are probably very basic. Employers must review original documents. They can't use photocopies. They cannot use Skype to see an original document across an electronic monitor. They have to have the person in their presence to do it. They haven't dealt with the agency hasn't dealt with the problem of remote hires, and that's still a difficulty that is faced increasingly with notaries being reluctant to serve as agents for the employers. No photocopies can be presented except for an original certified copy of a birth certificate. And obviously, documents that look wrong should be considered suspect. The requirements are the same as always in terms of the document must appear reasonably to relate to the individual in question. No discrimination by specifying documents that are required or asking for more than is the minimum. Hires before April 3rd of 2009, the documents may not be expired. Those are certain specific documents, and these are on List B. But U.S. passports were acceptable even if expired. But after April 3rd, 2009, all documents must be unexpired. Re-verification procedures are important, and I think people are aware of this because it's not new. The only thing that is surprising is that the latest version of the acceptable List A or List C documents must be used. So if someone was verified years ago and maybe a Social Security no-match situation or something suspicious has arisen that you have to confront the worker and ask them to re-verify employment authorization, they have to come up with a document that is now acceptable, even if the document they originally used was acceptable, but is no longer acceptable. That's also a problem for the situation of re-verifications as well. The receipt rule has been clarified. Essentially, it's a receipt for a document that in and of itself would have granted work permission, not a request to be employed under the immigration laws, which is not a valid receipt. I mentioned that only the most recent form revision should be used, and that's the same as the current version of the list must be used. Only the name of the person is written on the verification or the re-verification section if you do a new I-9 attachment, and you do not need to re-verify identity. It's only verification of the renewal of employment authorization that had been previously time limited. There's a special rule with regard to rehires if it's within 3 years of the original date of hire, or a choice on the part of employers to do a new I-9 for all rehires. The policy must be applied on a consistent basis, but there are special rules if the person meets the definition in the regulation in employment. That arises, for example, in the context of certain union workers, certain seasonal employees, and persons who are required text of an acquisition, whether it's a stock or asset acquisition. The post-hire compliance is always very important, and we need to cover the basic situations involving name changes, Social Security no matches, anonymous tips that seem to be reliable and contain verifiable facts asserted. All of these are going to raise a potential liability for failure to act. There's no turning a blind eye. Constructive knowledge is knowledge that would have been discovered if a person had done a reasonable investigation on a timely basis. And if the person did not, and I'm speaking of the employer did not pursue suspicious facts, then if ICE ultimately audits and finds that the individual lacked the right to work, the employer will be stuck with both a paperwork violation and a constructive knowledge continuing unauthorized employment violation, so it's very serious. Many employers these days are using I-9 electronic software, and we'll distinguish that from the E-Verify requirements. We know from one case involved had its IT department create their own proprietary I-9 software. Unfortunately, the software was not compliant with the regulations. The employer paid more than $1 million for the do-it-yourself approach. So it is extremely important to choose a vendor. There are numerous vendors that are dedicated to the I-9 process. There are others who added on to their HRIS, Human Resources Information Systems, offerings. I'd be more careful about the latter than with those that are dedicated to the I-9 process. All of these software vendors have to comply with audit trail requirements as to who touched the database at what time and what did they do. The government has the authority to demand printouts of the contents of your database, and all of these software vendors are hurrying right now to comply with the May 6th deadline for the new I-9. Now, one important point about use of electronic software is that beyond its accessibility throughout the network across state borders, is that it can be the database that interfaces on behalf of the employer with E-Verify, so that the employer knows what was put into E-Verify. If it were input into E-Verify directly, the employer may not have access to that data at a later point. So it's extremely important to consider the use of an electronic I-9 software provider, and most counsel can offer their tips and suggestions on this to proceed. The other thing that comes up is in E-Verify. I have some suggestions here. I am recommending that employers who have not enrolled do it on a pilot basis at one location only before full rollout nationally. There is a great infrastructure administrative burden on the part of employers to comply with the strict E-Verify time deadlines for tentative non-confirmations and terminations of employment. And unless you know what you're doing, this is a real problem. Also, the National Labor Relations Act has been interpreted by at least one region of the National Labor Relations Board that's out west here to say that an employer cannot, if it's a unionized workforce, on the employer's own without submitting this to collective bargaining, enroll in E-Verify. That is a subject that can be even more complicated when there is an acquisition of a workforce that is not on E-Verify and the employer wants to enroll and continue to enroll every new hire. This gets extremely complicated in the unionized workforce setting, so be very careful. The other thing to understand is that E-Verify can come up in mergers and acquisitions as well when an employer acquires an E-Verify workforce, or an employer that uses E-Verify acquires a workforce that is not on E-Verify, and it has to be decided carefully how that's done. That's swimming in the deep waters, so be careful about that. Let's talk a little bit about preparing for the potential of a government investigation. It's highly advisable to know where the skeletons in your closets may lie, and as a result, it's extremely important to consider engaging counsel for a voluntary self-audit, a compliance review, and remediation. The point that I would suggest is that do-it-yourself audits are very, very dangerous for a variety of reasons. No attorney-client privilege, the possibility that the people who made the errors in the first place are the same people who are doing the audits and would not know that they are engaged in repeating the same mistake multiple times. It's important also to know which government agencies can show up and what their procedures are. They differ across the spectrum of the departments of the federal government, and each has its own way of doing things. Employers are strongly encouraged to set up a protocol so that the people who are the stakeholders in the process, both internal and external, know the drill and know how to behave. Oftentimes there are unintended waivers of the Fourth Amendment protection against unreasonable searches and seizures because a secretary who wasn't given a heads up grants consent to inspect the premises when an investigator shows up. And so it is obvious that only certain people should be authorized to grant consent and waive the Fourth Amendment, that in-house counsel should be communicated with, in-house security personnel should be communicated with, and outside counsel, as well as, if it's a massive audit, it probably is public relations, and it may also be the subject of securities law requirements and Sarbanes-Oxley exposure. So the persons in the C-suite should be identified and made aware of what's happening and know what the proper responses are to a pending government investigation to avoid an inadvertent violation of securities laws. Obviously, it's important to know where the records are kept, and even more important these days is to have access across state lines, no matter where the records may be physically housed. There are special situations when dealing with vendors, unions, and mergers and acquisitions. Many people don't realize the immigration exposure that is absorbed when you engage a third party who brings their personnel onto your work site. There can be a co-employment relationship established under the immigration laws, with the employees of the vendor becoming co-employees of the customer. And while the old way of dealing with vendors was sort of Sergeant Schultz and Hogan's Heroes, who knows nothing and looks the other way, the more enlightened approach, I believe, is that which arose from a Walmart settlement some years ago, in which the customer puts into the contract with the vendor certain affirmative immigration compliance and policy obligations, including an obligation to submit to a third-party audit at the instance of the customer if there's reason to be concerned that the vendor may not be complying with the laws. There's also opportunities for indemnification in that situation. I mentioned the issue of the unions before, but just to be clear, the National Act does not trump the Immigration and Nationality Act, in that a union cannot command that an employer disregard the obligation to refrain from knowingly employing someone who the employer realizes has no right to work. That said, however, there may be a role in certain employment-related decisions, at least to consult with the union representatives in the context of a re-verification of the workforce in certain circumstances. This is a special area that intersects immigration law and labor law, and you should have both counsel engaged. Mergers and acquisitions present a special opportunity for those employers who are acquiring the assets and the personnel of another employer. If a workforce is acquired, due diligence is warranted, because given the existence of identity theft and fraudulent documents that may look to be genuine, a workforce could be hired. ICE could audit the day after the closing and determine that a fine is to be imposed, and that there should be an immediate termination of some significant number of the persons in the acquired workforce, which would make the value of the deal so much less, because most deals depend on the existence of people who know how to run things at the acquired workforce. Therefore, it's highly recommended that there be the engagement of a third-party audit to verify compliance on all levels with respect to immigration. These kinds of asset acquisition agreements should also cover immigration-related indemnity, and there should be a holdback of money that is for the purchase price, reserved until a reasonable time ensues, so that if there is a post-acquisition, post-closing investigation and fines are imposed, there's a clawback of that pool of money for the acquiring company to use to pay ICE. I want to let you see that we have quite a bit in terms of material for you to review on the last few pages of this. These are links that can be clicked. They're active hyperlinks, and they'll take you to some reading material that will give you a great deal of granularity around the issues that have been discussed in this presentation. I think that you can see they cover a wide variety of areas, and we are at that point when we want to allow questions. Now, Nicole, are we going to have verbal questions, or am I going to be reading what we have here on the screen?
You can go ahead and read what people have typed into the chat box. So we'll open up the presentation now for questions. Please go ahead and
okay,
type.
and there will I won't hear the speaker?
No. You can read
okay.
the question and
okay. Let me just
which ones you would like to respond to.
Okay, and where is the best place to see a clear explanation of which states require E-Verify? There is a website that maintains this on a state basis with a map, and I will share with the employers group that link after this call, and it's a pretty good map. You always have to double check, but it'll give you a beginning of understanding which states have the E-Verify requirement as a mandatory basis. Next question comes with the issue of an employer enrolled in E-Verify. Does that employer need to keep a copy on file of the I-9 form? That's a great question, and the answer to that is absolutely yes. There's a certain redundancy in the verification process when E-Verify is used as well as the completion of an I-9. The E-Verify process does not dispense with the I-9. The I-9 must still be maintained, but there are certain special situations, for example, dealing with certain forms of employee ID, where information must be entered from the I-9 into E-Verify, and it is an exception to the rule about employers not being allowed to in that some of these documents can't be completed in E-Verify. Some of these screens can't be completed in E-Verify if the information isn't provided by the employee. Regarding re-verification, do you have to have all employees complete a new I-9 every 3 or only at the I-9 expiration date? I think there's a misperception in this question. The re-verification only occurs in essentially 2 situations. One is where the individual has time-limited employment authorization and the employer has calendared before the expiration date on that time limitation to re-verify that the individual has obtained a new form of extended or renewed employment authorization. That's the most typical use of E-Verify, of re-verification. The other is where something has come up that raises that duty to investigate, that constructive knowledge exposure. It could be a Social Security no match, which could come from the Social Security Administration, could come from your insurance company, could come from your pension company. But if you receive information that the number being used is incorrect, then there are things that must be done to make sure that the employee is given a fair opportunity. It is not a guarantee of something involving an employment violation or an immigration violation by the individual, but it's a suspicious circumstance, and there needs to be a reasonable period of time to allow that. So those are the 2 circumstances in which this comes up. The next question, if a person used a U.S. passport as a valid document, and now, several years later, that U.S. passport has expired, do we have to re-verify that document? Answer, no, unless the 2 rules I mentioned earlier apply. If the person had time-limited employment authorization, and that wouldn't apply because a U.S. passport is not a time-limited document. It's an identity document, and it is inherent a grant of permanent resident. It's inherent in it a right of employment. However, if you have to re-verify someone, and that person now presents an expired U.S. passport as a List A document, they can no longer do that. That's an expired document. It has to be replaced by a document of the employee's choosing, either from List A or from Lists B and C. So no obligation in the ordinary course to go back when a U.S. passport that was unexpired at the time has subsequently expired, unless the duty to re-verify occurs, namely suspicious circumstance. If there's a suspicious circumstance, then there is. I'm just looking at the next questions. if we are not sure we are in compliance and we start to use an electronic I-9 company, we are considering to start over and have all employees complete new I-9s to ensure that we are compliant. Is this legal? I would say that an employer always has the ability to conduct, either on their own or with a third-party auditor such as outside counsel, a determination as to whether they are in or not in compliance. If that review process, that audit of a self-generated nature, reveals a substantial portion of individuals who seem to have errors on their I-9s that need to be corrected or remediated, or a substantial number of individuals who have presented documents that on second look appear to be doctored or fraudulent or incorrect in some respect, then it would be appropriate to consider a re-verification, certainly of the ones that appear suspect. It may also be appropriate, depending on the circumstances, and to avoid a claim of discrimination, to seek to re-verify the entire workforce. I would do that very sparingly, however. If you have a 95% error rate, I would suggest maybe the whole workforce should be reviewed. If you have a 30% error rate, I would suggest you re-verify those who have problems. And a re-verification can also involve corrections of the I-9s that are discovered to be not compliant from a paperwork perspective. What documents are to be kept upon completing the E-Verify? Well, the employer will be told on the E-Verify database what to print out for tentative noncompliance or non-confirmations, I should say, for permanent non-confirmations, for confirmations of employment eligibility. This is the reason why you want to use a software vendor that does electronic I-9s, because all of the documents that are fed into E-Verify and the database response can be preserved. And that is something that you want to have, because you need to defend yourself if you're going to have a USCIS desk review, as I mentioned before, or if you're going to have an audit. I'm going to pick up a different headphone. 1 second, because I'm hearing a lot of clicking. I'm not sure if it's coming from my phone. No, I'm still hearing it. So it's, I think it's from the line. Nicole, is there anything we can do to reduce that sound? Not sure.
We're looking into a solution for the sound.
Okay. In any case, expired I-551 forms. Those are the actual plastic alien resident cards that are issued. If those expire, you do not re-verify them. You may see that these have either a 10-year validity period or a 2-year validity period. These are not to be re-verified. There's not to be an inference drawn that the person may somehow in the future lose permanent residency upon the action of renewing and replacing the card. However, if there is verification based on what is called a temporary I-551 stamp put in the passport at the time that permanent resident status is granted, when that expires, you must re-verify employment eligibility. The USCIS is phasing out the use of those stamps except in emergency, so as time passes you will see those less frequently than you may have seen them in the past. If we are re-verifying for a third time, do we keep the prior I-9s attached? Absolutely. You don't throw away I-9s, and you must keep them attached. That's the importance of
reviewing them to see if there should be remediation and corrections made on the I-9 or on an audit slip that is attached to the I-9. I have team members that are hired in other states, and the I-9 is completed by the manager in that state. Can I then take that information and put it in E-Verify? Yes, it does not require that the person that completed the I-9 on behalf of the employer has to be the same person that does the data entry in E-Verify. Obviously, if the manager at the remote location has made a mistake, it's possible that there could be a mistake introduced in E-Verify, but if you're copying documents as well as completing the I-9, that would be less likely. Obviously, copying is an option that has to be done uniformly, and the copies must be kept with the I-9s if that is done. If no post office box is acceptable and there is no other address for the employee, what do you do? The government, I believe, has answered that in the M274. I'm not going to guess. My supposition is that this employee is either going to be treated as employed at the headquarters or employed out of their home. And I'm stumped. You stumped the expert on this one. I've got to look it up and remember, and I'll try to get back to the group on that one. Does the employee have to complete a new I-9 at the time of the I-9 expiration date? No. The I-9 expiration is on the form for purposes of the government's compliance with the Paperwork Reduction Act. You must use a form that is valid at the time of the hire and valid at the time of the re-verification, but the expiration on the bottom of the government form doesn't mean that re-verification is required. During a document retention seminar, we were instructed to keep I-9 docs for the greater period of 1 year from term or 3 years from hire date. Should we keep I-9 while employees are still employed? Yes, because it's the greater of 1 year from term or 3 years from hire date, whichever is later. And so an employee that is still the current employee has to have a current I-9 in place. We are a government contractor and required to E-Verify all new employees. Are we also required to E-Verify current employees? That will depend on a concept, if you are a federal contractor whose contracts contain a mandatory E-Verify obligation, that you determine which is more feasible. Can you reasonably only deal with the current employees who are assigned to the contract, or is it more logistically feasible to re-verify all current employees? It is your choice. And so the government has rules with respect to that. For example, HR personnel that are generalists and deal with all employees would not be assigned to the federal contract necessarily, whereas an HR employee who only works on that federal contract would be considered assigned to the contract, as well as those who are physically dedicated to work on the project. And so it's a choice. Bear in mind that there can be objections to E-Verifying current employees beyond the minimum required under the law, so that if an employer were to E-Verify all current employees and it was a unionized workforce, you can expect objection from the union. On to the next question. Are we required to keep copies of documents? I mentioned that before. The decision whether to keep copies or not keep copies is one that is an employer choice, but it must be done uniformly. And this can create problems when companies that are acquired have not kept copies, but the purchasing or acquiring company did keep the copies. There's no way to, therefore, once the workforces are merged into a single payroll, to have an inconsistent policy, and this may lead to the need to re-verify the workforce of the acquired personnel so that the rule regarding copies can be adhered to uniformly. There is nothing in the law that says you can do it by region, by division. It says an all or nothing for that particular employer. Certain seasonal staff are not required to re-verify. Can you elaborate? This deals with a concept that is specifically identified in the regulations, dealing with a reasonable expectation on the part of the parties of being rehired. So if you have employees, and let's take a farm, for example, and every harvest the same employees are rehired, and they may have some interim benefits maintained. But there are a number of factors under the reg. I can't get into all of them because of time limitations, but a reasonable expectation of continued employment is the test, and that's defined in the regulations. You may want to re-verify. It depends. There are strategic choices on that as well. Next question, do we have any way of requiring agents or unions who send over temporary workers to provide proof of the I-9s for those individuals? For instance, actors in a theater are typically hired through their agents and then arrive without documents because they do not want to travel with them. What do you feel is the best solution to stay compliant, especially when the contract signed by the agent and organization state we must pay the individual basis? Can we have the agents complete an I-9 certifying that they have seen the acceptable I-9 documentation? Well, there are two ways of doing this. If the agent falls within the definition of a recruiter for a fee, it may be appropriate for the agent in their own right to sign in lieu of the signing. On the other hand, if that is not the case under the definition of referrer for a fee, then the agent could sign as an agent of the employer. It would be a co-agency situation, and that circumstance would involve the employer assuming any liability arising from an error on the part of the agent. So if you're prepared to accept liability if the agent makes a mistake in completion of the I-9 or violates the rules, then you could do that. But I think it may be that you need to adopt a more serious policy about insistence upon the actors in that fact pattern carrying their original documents of identity and work authorization or not being employed. Where can we find the regulations outlining seasonal staff? I will include that in an email to the employers group so that you can find them. And with that, I have no more questions, and I am actually out of time anyway. So I want to thank the audience for their attentiveness. I hope that you found this of value. Bear in mind that this is extremely complicated. The person is typing. I may have one last question to answer. Oh, no, they're saying thank you, and I appreciate your gratitude. But the point that I would make is that this is complicated stuff. The government has foisted on employers the deputization of the law enforcement function, and regrettably, employers have to dedicate resources of time, money, and outside counsel fees for complying with these rules, because not only does it entail a potential for fine and imprisonment, even in a case of low violations, it can involve damage to the company's brand and employee morale. So I want to thank everyone in the audience, and at this point, our session has concluded.